morning, everybody, and thank you for joining us. My name is Kurt Nola, Director of Member Relations here at Barnabas Foundation. And joining me today is Adam Lopez, one of the members of our state planning, our planning group, planning team. And Adam comes to us. He's been with us now for, remind me, Adam, 3 years now or longer now?
It'll be 3 years in September, which is hard to believe.
Right around the corner. And prior to that, Adam spent many years in estate planning law, practicing law in the Wisconsin area. And then came over to Barnabas Foundation to join us on the fine work that we're doing here in working with thousands of families across the country in their estate planning and gift planning needs. A few housekeeping items before we get started on today's topic. Today's session is being recorded, so if you'd like to share the information that you are hearing today with others in your family, your friends, or associates at your office, you'll be able to find the recording of this today's broadcast at barnabasfoundation.org/interactive next week. It should normally be posted by Monday or Tuesday. And also at that site, you'll find previous client live recordings like this, where we cover a wide range of topics. And so feel free to peruse that library as you need to. Today, you can also ask questions. If you do have a question throughout today's broadcast, feel free to type it into the Q&A portion at the bottom of your Zoom screen. It'll come up on my screen here, and we'll address those questions as we're able to throughout today's broadcast. Now, a quick little summary about Barnabas Foundation. We have been around for almost 50 years now. And our organization is a member service organization. What that means is over 200 member ministries have banded together to have this organization be available to them to provide planning, gift planning, and estate planning expertise to their supporters. As a result, the work that we do is all completely at no charge to you because these member ministries, many of you were invited by a member ministry to attend today's broadcast, have made it a priority to have this kind of expertise available to you as you consider ways in being a good steward of everything that you've been blessed with by the Lord, both during your lifetime as well as in your final act of stewardship. And today's topic is really on the issue of what has you stuck in estate planning. And over the years, we've worked with thousands of families across the country, and quite honestly, many of them were stuck on some topic at some point during their planning process. And that's not necessarily an obstacle that has to keep you from finally getting things done. And today we're going to touch on some of those topics and some of the strategies that we use to help families move beyond those particular stuck points and get a plan put together that ultimately honors God and provides for both their families and their charities in their final act of stewardship. So today, Adam, just kick things right off. What are some of those, broadly speaking, what are some of those things that often families get stuck on during their estate planning process?
Well, Kurt, there's a lot of areas that one can get stuck on when it comes to estate planning. When we wake up in the morning, our first thought when our feet hit the floor is not, if I predecease my spouse and the kids are minors, what should the distribution be? Or vice versa, or who gets my Corvette, or any of those things. But those are the decisions that have to be made when you are creating your estate plan. So when people come together to finally do the estate plan, they are confronted with those choices. And because people have differing opinions, it's not unusual for those choices to create these obstacles. And it's very common. I would say in my years in the estate planning business, everyone has had at least one sticking point where they weren't totally sure of what they should do. And so to put it into easy sums, the three main areas I see that people most commonly get stuck in are how much is enough for your beneficiaries, loved ones who are in difficult circumstances who will be a part of your plan, and who's administering your plan, who is the trustee, who is the executor, and who is the guardian of your minor children if you have some. So those are the three biggest areas I see where people get stuck.
Excellent. Well, let's start with the first one that you mentioned when it comes to beneficiaries. What are some of those issues that are often that we wrestle with as parents or as asset owners of around beneficiaries and who's going to get what?
The number one issue that people wrestle with when it comes to beneficiaries is how much is enough? How much is too much? And settling the issues between those two juxtapositions. I've sat in a lot of living rooms, a lot of kitchen tables where for the first meeting, we may discuss only that issue, depending, and it's a big one. The Lord's, placed the responsibility on us to manage the assets he's given to us, but he's also placed on us the responsibility of caring for the loved ones he's placed in our family. And so this is the big question. And so one thing that I found is helpful for couples, and I'll use an example to illustrate. I met with a couple, they had 3 children, all adults. Parents were nearing retirement, and they needed to update their estate plan because their estate plan had been from when the kids were little. So a lot of it was no longer relevant. And so looking at their kids' lives, they said, or I asked them, in a perfect world where no one has an opinion on how your estate should be distributed, can you both state for me what the distribution would be and why? And they agreed 100%. Not even close. So the wife goes first and she says, well, looking at our children, they have good jobs. Their spouses have sound jobs. They're doing well in life. I think that a good gift for them would be each of the kids receives 10%. And then 70% I would like to see go to the charities that we've been supporting all these years. So that was her perfect world distribution. Turn to the husband. He's looking at the wife already saying, oh, I didn't know you thought that. Well, here's what I think. And he thought that 60% of the estate should be split equally between the children and 40% should go to the ministries that were close to their heart. So there's a big difference between the two, virtually double. The father thought double should go to the kids than what the mom thought. Now, the dad's rationale was the kids are doing well, but life is uncertain. We don't know what sort of circumstances may pop up tomorrow. There may be a loss of job, health crisis, bankruptcy, downturn of economy. And so his rationale was, I want to help give them an extra pad in case those things happen. And secondary, he wanted to make sure they had money that they could bless their children, so their grandchildren with. And then he thought a nice gift to the charities that they've been supporting all these years would be the 40%. Mm-hmm. And so they were at odds. And so now that we've stated our perfect world distributions, we have to find a way to bring those together. And a great way to do that is to add dollar values to those percentages. Because when we're talking about percentages, it's easy to throw around 70, 30, 80, 20, what have you. But as soon as you enter dollar amounts to those, now we actually see the value currently, what the current day estate is, and that helps us delve into questions of, okay, well, what do we want them to be able to do with this? Do we want them to be able to pay down a mortgage, pay down health expenses they've incurred, have some money to invest in other investments? And so when we started doing the math calculation, we actually discovered mom didn't realize that 10% was the sum that it would be. And she thought, oh, actually, I do think my kids might need more than that. And so we were able to then run additional scenarios. What does 12% look like? What does 15% like? And eventually we're able to bring mom and dad closer than where they originally started. Mm-hmm. So adding those values really can help the discussion because you can more accurately discuss what are your hopes for this money based on your kids' needs. And then if you're still stuck after that, a great question to ask your planner is, well, what do other people do? What have you seen other people do? Because your planner is going to have seen a wide variety, hundreds if not thousands of estate plans before they plan yours. And so sometimes that's an easy way to break the logjam of, hey, here's some other people in similar circumstances, and this is what they did.
Mm-hmm. Excellent. Oftentimes in some of these families, there's a specific asset involved, right? A business or a piece of property that they want a specific child, or perhaps it's business and that one child out of all of them is actually actively involved. That can be a big roadblock for some folks. How do we help steer that conversation sometimes?
Mm-hmm. Definitely. I see this a lot. I work with a lot of farmers, and it's not uncommon for one child to be interested in farming and the other 3 not so much. They've gone on to different careers, mm-hmm. But because farms are very asset based and they're not liquid, so it's hard to divide those things. So in situations like this, you're really looking for, are there other assets, liquid assets, that could be given to the children who are not interested in the business? If there are, that's an easy way to say, okay, well, if the one child gets the business, the other children get everything else, and we can get as close to equal as possible. Sometimes it's not always possible to do so. That's one option. Other people will say, okay, we're going to place the business, we're going to make each of the kids an equal shareholder in this business. And it's the responsibility of the one who wants to own the whole business to arrange at financial terms with the siblings to buy them out. And so that leads to a conversation of other complexities that are probably beyond this topic. But there are those options where you can start out as equal shareholders and have a plan in place to say, okay, we want son or daughter to be the one that buys out the other siblings, and kind of lay out those terms in the trust so that it's clear. And that brings up, if you have a family business, please talk with your corporate lawyer about having a business succession plan in place, because having one of those in place will allow for life insurance policies to be placed on the current business owners, so that when he or she dies, there is liquid funds available for your children to buy each other out of that share. So in a family business, it's really important to have that business succession plan set.
Yeah, great example. Thank you, Adam. And second marriages often create some significant complications, as myself has experienced, in terms of how they plan, and what do they do for each of the children. And sometimes, especially with minor children, divorce agreements are still in place and all kinds of things. So we've run into that many times, I know, and where are some of those roadblocks, and how are we guiding people around those?
Absolutely. These can be some of the more difficult estate distributions to solve, because each spouse will often have children from the previous marriage. But now the two of you are married and you want to build that life together. But it's not uncommon for one spouse to have more assets than the other. So the question becomes, are my assets going to be divided equally between my children and my new stepchildren? What is the right course of action there? And for some people, the way their family is constituted and the family, relationships, that might be their choice. They might decide to do an equal distribution across, all the kids in the family, especially if a child is born of the second marriage. Now there's a child between them. What do you do with that one? And a lot of times in those cases, I see, okay, well, if we have a child together, maybe we do an equal distribution. However, there are a lot of times where people say, no, my children need to benefit from my assets that were before the marriage, and the child we have together will benefit from the assets we create in this new marriage together. Sometimes it's necessary for husband and for wife to each have their own trust, and for certain assets to be allocated to each trust, and each trust has a distribution plan that is different from the other. When it comes to the children from these previous marriages. And so these are difficult decisions to have. But again, I say start with, what is your dream scenario where no one has an opinion? Step way back, zoom the lens out, and dream a little and say, okay, we would love it if it was this. That will give you a baseline to start from, to start working towards more of common ground.
Excellent. Adam, as we're going here, we've actually had a question come in, and just a reminder, folks, if you do have a question throughout today's broadcast, feel free to type it into the Q&A. And just a reminder too, for everybody's benefit, this is being recorded, and so you'll be able to access the recording next week once we have it posted to our barnabasfoundation.org/interactive website. So you'll be able to watch this in full, as well as to, perhaps you misheard something or want to review it again, or just want to share it with a spouse or children or other family members of the like. But the question came in, can you discuss at what age beneficiaries should come into their inheritance, and whether it should be given in stages or all at once?
That's a great question. And it segues a little into the next section, but let me just address that specific question right now. Under the law, you have to be 18 years of age to inherit. Now, that by no means means that you should inherit at 18. I think we all know a lot of 18-year-olds that probably would not do well when handed a large sum of money. So the law allows you within your estate plan, as long as someone is over 18, you can select the age at which your beneficiaries receive the money. Now, there's a whole host of reasons as to why you would give an outright distribution as opposed to spread out over time. But here's what I see a lot of people do. A lot of people will select the age of 25 as the age that a beneficiary should reach before they get an outright distribution. The thought pattern there is that by 25, hopefully they most likely finished their training, in whatever vocation they've selected. They've had a few years to work in that vocation, learn about how bills work, how finances work, how debt works. And hopefully by 25, they're ready then to make responsible choices with that money. For some people, just, all kids are different and people mature at different rates. For some of them, it wouldn't be good if they receive all of that money at once. So in those situations, if the money handling issues are not serious, the hope would be that as they age, they would grow in maturity and in skills in handling money. So people will meter over time the distribution. A popular one I see is at 25, they will receive a third of their share. At 30, they'll get half of what's left. And at 35, they'll get the remainder. And you can play with those numbers however you see fit. But I always tell people, your beneficiary is the best. What age, based on how they are now, what do you think should be the appropriate allocation there?
Excellent. So that segues right into that next topic that we want to touch on today, which is really around children and loved ones. Oftentimes, we love our children dearly. I have 8 of them between my first and second marriage, and so love them all to death. But there's some uniquenesses between each and every one of them, and thankfully we don't have any drastic special circumstances. But each one might have their own unique needs down the road. And so given that, what are some of those roadblocks we run into and some of those things that we see, and how do we help people push beyond some of those issues that come into the special circumstances that our loved ones often have?
Absolutely. I would say there are 4 main areas that I see in what we call these special circumstances, and that's beneficiaries who have physical disabilities, beneficiaries with mental health or mental disability issues, beneficiaries who have some sort of an addiction, whether it's drugs or alcohol, and then beneficiaries who have serious money handling issues. So what to do? We love our kids. We want them to benefit from our estate plan, but there are times where it is better for them if we place restrictions on those distributions to them, so that the inheritance is a blessing and not a hindrance to them. So this is where the roadblocks come up, because there are 2 main camps of restrictions. There are ones that are more legally advisable that you probably should have in place based on the situation. And then there are restrictions that are more discretionary. The problems aren't as severe, but they're still needed. So that second category is where most of the roadblocks come into play. So let me first address the first category of where it's most beneficial to have, where you probably should have these restrictions. That's in situations where a beneficiary of your estate is on federal or state benefits that provide. So they're in situations where they cannot provide for themselves, for their daily needs, for their health insurance, for the therapy they need. And so they're on these programs that are put out by the state and by the federal government. These programs have rules about how much money you can receive per month outside of the benefits. And if you exceed that limit, you will be kicked off the programs, forced to spend down that extra money. And then once that money's been spent, you can then reapply. Well, that waiting period between having spent the money and reapplication can take months, and that can often leave these beneficiaries in a difficult situation. So if you have a beneficiary like that in your estate plan, talk to your lawyer about their share should go through what's called a special needs trust. Quick explanation of what that is it says that the beneficiary does not have a right to that share, but the trustee of the special needs trust can use that share to supplement their income. So the rules will say you can receive up to $2,000 of outside money per month. So that's what the trustee will do. Every month, they'll distribute no more than $2,000 from the trust to that beneficiary, allowing them to keep their benefits, which they need for their livelihood, as well as to benefit from their inheritance. So usually no roadblock there. Everyone's in agreement. Okay, that's how the law is. This is what's best for them. Let's do that. The second category, where it's more discretionary restrictions, is where the roadblocks come in. Is it fair to place restrictions on one kid and not the other? This is a big disagreement between parents. We should treat them equally. Well, maybe one parent doesn't have as much concern about the money handling problems of the other. And so this is where the disagreements typically arise. And it's usually for people who have money handling issues or drug addiction issues. So they're not on any sort of benefits. It's just they know if you give them a large sum of money, this is not going to do right for them, or they're not going to operate well with that. So again, I go back to if we're having this disagreement, both of you state big picture, perfect world, what would you want? And depending on the needs of that individual, then you can start to break things down into more digestible portions. So let me give you an example using a case that we had last year. So we met with a family and they had 5 children, and of the 5, 3 of them had these special circumstances. And so it was a difficult conversation because the parents had a lot of decisions to make about how they were going to care for their kids when they were gone. And the 3 with special circumstances fell into each kind of one of those categories. There was one who could not operate on his own. He could not provide for himself. His mental conditions were such that he needs care, and he'll have to be taken care of for his life. So that was the starting point as we started discussing, okay, for him, he needs care for the rest of his life. How much money should go into his trust? What are the costs now for his care? And what do you think conceivably could the increases in cost be over time? And then we start to walk through those calculations, and we're doing a bunch of math. But writing out those numbers helped them say, okay, we need more than we initially thought because he really needs care. So their answer was more money for him because of his situation. The second child, they had some mental health issues, but it was mostly drug addiction and money handling issues. But it wasn't to the level where it was to the level where they thought he shouldn't touch the money. He shouldn't have direct access. So what they settled on for him is they would put a sum of money. We went through the math of what they think he would need based on his situation, what debt does he have? What would they like him to be able to do in the future? And they put a trustee in control of his share where that child could make requests and say, I need a car to get to work. Would you buy a car on my behalf? So the trustee would be making those purchases for that child. So the child's hands would never touch the money. And in that way, the parents thought, okay, this is the best way that we can benefit him. Still provide for his needs because the trustee has discretion, but he's never going to touch that money. The third child had some money handling issues, but he was young. And so their hope was that over time, he would mature and be able to use that inheritance more effectively. So in answering that question, they went with a metering distribution. They selected at age 30, he gets a third, 35 half, and at 40, the remainder. And so when you're having these conversations, this is kind of the process that's helpful to go through. But there's a secondary part to this. Once you've made the decision on what restrictions to place, have what we call a family meeting, where you bring your kids together and you tell them a couple of things. 1, you love them. 2, God has placed you in charge of these assets. And so it's up to you as stewards to follow his leading on that. And 3, that you want to make sure that they are provided for. And then you explain the plan to them and then allow them time to ask questions. Because the other part of this story or this example was there were 2 children who were doing very well in life, and they were going to get a lot less out of the estate than the others who needed help. And so they needed to have the conversation with the parents to understand, look, it's not that we love you less, it's that you need less from the assets that God has given us. And having that family meeting really can relieve tension and allows them to be heard. Even if your decision is final, they still get to ask questions and hear from you directly.
I think that's a great point there, Adam. The conversation you and I had once about, I think we were in Colorado meeting with a family and they were dealing with some similar issues. And the idea came up that you're loving your children equally, but you're treating them uniquely for their circumstances. And we actually had a question come in from Ken, who's got a similar situation where he's got several children, and one child there is a spender and the other ones are just fine. And I think the advice there, Ken, is what you just heard, is be thinking about perhaps putting a trust in place or metering out that distribution to that child over time, even though the rest of the children maybe get everything in a lump sum, because you know the circumstances around them. And let's be honest, these are your dollars, they're not your children's, right? These are your dollars you've been blessed with. You have control of this. While legally under the law, if you don't have a plan, they'll inherit it, and that's true, but it's still your responsibility to be a good steward. And we talk about this. Your estate plan is your final act of stewardship in the eyes of God. How are you distributing these things? And so if your children need to be treated very uniquely, we encourage you to do that and to wrestle with those hard questions. And we're here to help you with that. And so before we jump into the next topic or the next question we have here, I just want to address some of the other questions that have popped in here, because we've had several, which is great, and encourage all of you to ask any questions you might have. We're happy to spend whatever time we can answering them. Should IRA dollars ever go into a trust? And I would assume we're talking about any type of trust, whether it be a regular trust or a charitable trust, or would that hurt in taxes in any way? So do you want to comment on IRA assets really quickly?
Sure. We talk about this with individuals all the time, what to do with your retirement money. When your children inherit, if your children inherit that money, they will be taxed on it. And the rules have changed recently about how they inherit that money and how they are taxed. If you give it to a non-spousal beneficiary, they now have 10 years to allow that money to grow tax-free, at the end of which the taxes will be removed and the remainder will be sent to the children. Now, at the compressed time frame, the tax hits probably, depending on your tax bracket, going to be somewhere between 35 and 40% of the taxes. So the government is basically trying to get their tax money faster with inherited IRAs. So whether you should leave it to a trust, I'll give you the classic lawyer answer. It depends, because if you have someone with special needs, and that's a majority asset in your estate plan, you might have to place a portion of that through your trust with a special clause that says, the funds that come from this IRA account number, yada, 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 are to benefit this beneficiary through their special needs trusts, because there are some exceptions there. So typically our recommendation is if you're looking at your IRA assets and you're looking at your kids, if you're also including charity as part of your estate distribution, funding the charitable portion with those IRA assets is a really great thing, because no taxes are taken out of those portions. So if it's helpful, we'd love to have a further conversation with you to find out more specifics. It's hard to give exact, advice just from in this setting, but if you'd love to talk with us, we'd love to find out a little bit more about what's going on there.
Thanks, Adam. And just addressing a couple other questions that popped in here. Maria, thank you for your question about income taxes. In certain assets in an estate, the heirs will pay income taxes. Those are primarily retirement-based assets like IRAs, 401ks, and those things. When they inherit those dollars, if you're at an estate tax threshold, the estate pays that tax. But there's also certain state circumstances where heirs actually pay an inheritance tax. So there's a handful of states that I know have an inheritance tax. And so it depends a little bit on where you're located, but we would be happy to help you figure that out in greater detail. And our contact information will be on our screen at the end of today's broadcast. Renee asked, can you set a time limit where the trust cannot be changed after the death of the first person in terms of a couple? How might you wrestle with that, or is that allowed?
It is allowed. I would say standard trust language is that for a married couple, the surviving spouse has full power to amend the trust as they see fit, because they are continuing to live. They need the marital assets to survive for the remainder of their lives. But sometimes people do have concerns. I'll say the one I've heard the most is that the surviving spouse is going to remarry someone younger and blow all the money, and nothing will go to the kids. So if that is a real concern, you can restrict that upon the death of the first spouse, the certain portions of the trust are locked in. And so what some people will do is they will set aside certain assets that are for the children only, making sure the surviving spouse has enough to live on, but setting aside certain assets for the kids upon the death of the first spouse, so that they can ensure that something's going to the kids, and that in that hypothetical, the surviving spouse is not spending it all away. So it is possible, but you should talk further with your lawyer about some of the complications, because anytime you restrict someone's ability to change things and they're still alive, that can cause some issues for those left behind.
Thanks, Adam. One last question that's coming on so far is, how do I find a Christian attorney? Well, a few ways. I would encourage you to talk to your friends at church and see who they've used and who might be in your network of people. We have a network of Christian attorneys that we have worked with, that we've had conversations with. In some cases, we have vetted. And so we may be a resource to help you find a Christian attorney. And there's some other services like Christian Legal Society that you can go on and do searches on. There's also a group called Kingdom Advisors. Has a handful of attorneys in it, mostly financial advisors, but there are some attorneys in the Kingdom Advisors Network. So those are all places in which you can turn to search for a Christian attorney in your specific area. So one last topic. I know we're running a little longer than we usually do, so I appreciate everybody bearing with us right now. But one last topic is really on the issue related to trustees and executors and guardians, and oftentimes we get this question is, I don't know who to choose. And so how do we help folks think through that issue? And it's a pretty substantial roadblock for some people.
It is. This is the individual or individuals in the case of co-trustees or co-executors who are going to be responsible for putting your plan into place. Now, when you pass away, your plan is irrevocable. The terms of the trust must be followed, but it's still a big responsibility. And so as usually people each have someone in mind that they think would do a really great job. Let me give you a couple of factors to use when evaluating people. And I think it's a helpful way to figure out, okay, maybe this person is not quite the right fit. So the first factor would be trustworthiness. They're going to be handling finances for your family. They will often be privy to, certain family knowledge of situations, because that might affect the distribution. To make sure they're trustworthy, make sure that they're the type of person that when circumstances get tough, they're going to persevere through. Because all of our hopes is that our distributions go swimmingly, quickly and without any issues. But there are times where there are hiccups, and you need the trustee to be someone who will persevere through those. Second factor is proximity. If it's at all possible, if that trusted person lives in your locale, that can be very helpful. A lot of times the trustee will have to do things such as sign at real estate closings, be present at the bank to gain access to the bank accounts of the deceased so that they can distribute the funds, gather life insurance and retirement benefits. And so proximity can be very helpful. In situations where you don't have someone close, it is one of your powers as trustee is the ability to hire someone on the ground to help you with that. But that's an additional expense, to the estate. But if it's necessary, that's a good option. And then the third factor I would really say is organizational skills. There's a lot of details involved in the administration of an estate. Someone who's familiar with paperwork and financial instruments can be helpful, but someone who just has a good sense of organizational skills to keep all of their tasks before them and make sure they're crossing those off. So those are usually the three main ones that I tell people: look at your candidates and stack them up against those requirements. Who's the best fit? And then pick a secondary one if that first one is unable or unwilling to fulfill their role. Have a backup.
Thank you, Adam. And for your all benefit who's watching today, that is something that we often touch on during our estate planning sessions with folks, is helping them wrestle through who are the persons or individuals you're going to choose to be those executors, those personal representatives, those power of attorneys and guardians for children and minor children. One other question popped in: is there a tool to create a will that we would recommend? Always a sticky question when you ask this question with an attorney online. But yes, we actually have access to an online will planning tool. It's available at barnabasfoundation.org/giftwise, GIFTWISE. For GiftWise, it's an online will planning tool, very simple, very intuitive, easy to use. The great thing about it, at the end of it, you can actually duplicate the will for your spouse. And so if you're doing this as a couple, it makes it really easy to do. And quite honestly, in the matter of minutes, you can actually generate a will that you can sign and have notarized in its official document in your state where you may reside. We will caution, of course, to say that if you have any level of complications in your estate outside of just a traditional home and retirement accounts, or any nuances to your estate that requires some special thinking, some special circumstances, perhaps complex assets, perhaps assets you hold across multiple state lines, you probably want to talk to one of our attorneys and think through the planning of that before you go and run and just do a simple will through GiftWise. It really is designed to be that kind of first will for simple estate plans, and not something to address more complicated situations. So thank you for those questions. It's been fantastic today throughout.
Can I make 2 quick final points? Is that okay?
Please, absolutely, Adam.
I wanted to mention on the trustee or executor issue, sometimes there's not someone nearby. Family may be all overseas, or the relationships in the family dictate that there might be contentious, and there might be litigation after the distribution. Sometimes it's necessary to have what we call as a corporate trustee. These are professional companies where it is their sole job to administer estates. So they're familiar with the complexities, they're familiar with how the court system works if that becomes a reality, hopefully not. But they're not tied into the emotion of the family. So in situations where there is a lot of tension, a corporate trustee might be a good route to go. And then real quick, because I know we're running long, guardian of minor children. That's a big issue for a sticking point for people. Is how do you decide who's a good guardian? Couple quick things. Number one, who would raise them? Who's on the same spiritual level kind of as your family, that they have the same spiritual focus? That's an important one to talk about with your spouse. 2, do they have the capacity to take on your children at this point in their life should the worst happen? Are they in your locale? It can be great for kids, they've lost their parents, so they're in a nightmare, but to still be in the same location where they have friends, other connections, can be a great factor to think about. And are they wise with handling money? Because they will be entrusting them to manage this money and take care of your kids. And 5th, ask them, are they willing to fulfill this role for you? That's a great conversation to have when you're considering who should be guardian. For my wife and I, we did that. We still couldn't agree, and so we actually flipped a coin. We were both confident that both candidates would do a great job, but we just could not decide between the 2. So don't overlook the flipping of the coin option when you if you know both options are qualified. It can help break that down.
I think today's topics actually demonstrate how we help families through their estate planning process. There's a lot to think about when you're thinking about all that you've been blessed with and accumulated over your lifetime, and how ultimately you're going to distribute those assets. And then when you factor in special circumstances or minor children, it really starts to get things to be a bit complicated. And in our planning meetings, we touch on all these things. And as a reminder, this is a complimentary service that you have access to these experts available to sit down with you, either over Zoom or perhaps in your home across the dinner table with you, talking through these issues, helping you wrestle with these hard decisions, and coming up with a blueprint for your plan, a roadmap for your plan that you can then take to local counsel and have it drafted. And we have a network of Christian attorneys that we can certainly refer you to. We have created a document that's called Roadmap to Complete Your Will. And if you'd like to have a copy of this, feel free to email us at info@barnabasfoundation.org. And it's just kind of a quick summary of some of the various different topics that we touch on during a planning session. And so, again, if you need help, if your plan is even, perhaps it's a little dated. One question I ask folks all the time when they say they already have an estate plan is, the question is, does the plan reflect your values today and your circumstances today? And oftentimes the plans, they change over time, and they need to change over time. As we age, as our children ages, as our grandchildren are born, as kids get married, and all kinds of circumstances would justify having those plans updated. And so we're here to be of service to you. This is our ministry. This is the ministry we are called to do in helping people do this planning and ultimately be great stewards of all that they've been blessed with, both during their lifetime and ultimately that final act of stewardship in their death. As a reminder, today's session was recorded again. It'll be available at barnabasfoundation.org/interactive next week. I'd ask that all of you that are still online and participating to, there's a short, very, very short survey at the end of this broadcast. We would encourage you to answer those quick few questions so that it just helps us improve those things that we make available to you at future recordings. And if you didn't notice on the opening slides, our next session like this will be on November 8th. We'll be talking about strategies for the giving season, and you can find more details about that again at barnabasfoundation.org/interactive. If you have any questions whatsoever or have planning needs whatsoever as a result of what you heard today, please reach out to us at barnabasfoundation.org or call us at 888-448-3040. Our contact information will be on the final slide here at the end of our day. We'd be happy to help you. You can also contact the representative at the member ministry that invited you to today's broadcast. They're all member ministries. They know how to get in touch with us, and they would love to help make that introduction and bring you, assist you in this planning process. So that's all for today. I thank you for sticking with us. We did run a little longer than we normally do. We normally are around 30 minutes. So I appreciate everybody that stuck around here. And Adam, just thank you so much for your expertise and sharing your knowledge with everybody today. Be blessed today. Enjoy your day. Bye-bye.